Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate. Har Har Mahadev Jai Shiv Shambhu. In today's class, we will discuss about call location, CDR, and its importance in cases under Prevention of Corruption Act. So basically, we have to work out on the brief. We have to work out on the law point so that if we are having the same issue, we could work out as per law. First of all, we have to note down the topic, call location, CDR, and its importance concerning the cases under Prevention of Corruption Act. Then directly I am coming on the law point. Judgment in that regard is pronounced by Honorable Delhi High Court. The case title is Mangal versus State of NCT. Judgment is pronounced on 10th of October 2025. So I think that I have provided all of you the basic details about the law point along with the credentials of the case title. Now I am coming on the brief. In that case, the application was filed by accused to preserve the call detail and CDR, but the same has been dismissed. At this junction, I request all of you to note down two important concepts: preservation and summoning. As far as Section 91 of CRPC is concerned, which in nowadays is Section 94 of BNSS, it entirely empowers the court to summon any document which is relevant for the disposal of the case. But whenever we demand for summoning, the court may dismiss our application. So preservation is the good course. So in that case, a request was made to preserve the call detail. But despite of that, the prayer was rejected. In that case, the accused persons were booked under NDPS Act. Unlike Prevention of Corruption Act, NDPS Act is the special act. In that case, the application was filed as per Section 91 of CRPC, which is also called Section 94 of BNSS, with a prayer to preserve CDR, call location of member of raiding party and duty magistrate. But the key point is that the application has been dismissed by the concerned court. Now the important question arises, what to do? Simply, you have to go before Honorable High Court. But please mark my words, against order of Section 91 of CRPC, revision would not lie. We have to file the petition as per Section 528 of BNSS. Now the important question arises, while drafting the petition, what facts are to be kept in our mind? Number one, why there is need to preserve the CDR or call location? Because the concerned presiding officer of High Court may make the inquiry. So basically, we have to specify to the concerned court that the concerned location with CDR is sine qua non to provide the accused the opportunity of being heard. Because if the case is under Section 7 of Prevention of Corruption Act, there is a presumption of Section 20 of PC Act. And to rebut the presumption, opportunity of being defended must be given. If document is not preserved, and in case there is inconsistency, at that time the document is required, the prosecution may say that it is not available. And that's why, to provide the opportunity of being heard and to provide the opportunity of fair proceeding, the document is required to be preserved, because in case there is any inconsistency and document is required, the court may easily summon it as per the law protocol. So on that scenario, we could emphasize. Apart from that, we have to emphasize on judgment of Honorable Supreme Court. Citation is 2024 SCC online, Supreme Court, page 1833. In that case, it is observed that the opportunity of being defended and opportunity of fair trial must be given to the concerned accused. In addition to this, the case of CBI versus Neeraj is quite important on that subject. So, in the present case in hand, the concerned trial court has rejected the application on the ground that before framing of charge, application cannot be moved. It is right that before framing of charge, the application could not be moved. But if the prayer is regarding the preservation, not regarding the summoning, in that scenario, the application is maintainable. So, Honorable High Court set aside the order with direction to preserve the call details. So, by the bare perusal of said judgment, it is quite clear to us. Before framing of charge, the application could be moved. Number two, application is required to be moved as per Section 94 of BNSS, Number 3, the prayer should be of preservation, not summoning. And number 4, we have to assign the specific reason why call details or CDR is saying one on. If we draft the petition in the set protocol, in that scenario, we could be succeeded. But in case the application is dismissed, do not go for the revision. We have to file the petition as per section 5 to 8 of B and SS to seek remedy, because as per judgment of Honorable Supreme Court, the revision against the order of section 19(1) of CRPC, which in nowadays is called as section 94 of BNSS, would not be maintainable. So these are the important information concerning your right. For such updates in English, please follow, like, subscribe my page so that such information could be with you within the time framework. See you in the next video. Till then, Jai Hind, Jai Bharat.